Former President Jacob Zuma has lost his latest plea to have advocate Billy Downer removed as a prosecutor in the arms deal corruption trial. Judge Nkosinathi Chili, who presided over the matter, said he was not persuaded that Zuma's legal counsel had succeeded in establishing their case. Chili did not give any reason, but said he would provide them at the end of the trial. For some analysis on what this means for the former president, I'm now joined by legal expert Mpumelelo Zikalala. Mpumelelo, always good to speak to you. Let's start off with an explanation of the concept of Stalingrad tactics as it pertains to Jacob Zuma's legal team and his strategy. And this is a term that we've heard for many, many years now.
Definitely. Good afternoon to and also good afternoon to viewers. Well, they use that claim that has been made by the NPA to say, Mr. Former President, the way you are engaging in this litigation, you are trying to find any other reason than to attend court, any other reason to delay it than to the first witness go into the witness box so that you are able to defend yourself. If you really do say that you are innocent, allow us to present the evidence, and then you can be able to dispute that evidence, and the court will be able to make a finding. So the number of times that you should go to court and receive these postponements would have been utilized with hearing evidence and making sure that you are able to clear your name you have always claimed. So any other tactics that might be there are always viewed or predominantly viewed by the NPA as Stalingrad activities and not something which is genuine in terms of those objections.
So Stalingrad tactics might be unethical, but absolutely legal.
Yes, they are. It all goes back to say that whenever there's a complaint which is allowed, that you can be able to complain about, and it must be resolved by a court of law, then you must be given an opportunity to do so. Even our constitution, it does say any dispute that might be there between us and the state must be able to be resoluted by a court of law. So the same applies. And then if you again look at the Criminal Procedure Act, which gives us basically the manual on how to handle criminal cases, if there's a section that says you can challenge any sort of things, that section must be there, and you must be able to utilize it as you please. So the engaging or the utilization of those particular activities can't be said that you are now engaging in any Stalingrad activities because you're simply exercising your right and making sure that, yes, I want to be tried, but I want to be tried in a manner which is fair and in a manner which is compliant with our law.
Now, Judge Nkosinathi Chili did not disclose his reasons for that last denial, if you will. Is this part of his strategy to avoid further interrogation and more use of the Stalingrad tactics?
It could be to try and say, well, I want to turn this the judgment or the results that were issued last week as a ruling and not as an order. So it should be to say it does not have any final effect. You can go on and say, I want to be able to hear evidence in this case and not to delay it if that particular reason is going to be challenged and taken to the SCA or even the Constitutional Court. It may be that the judge was thinking in the foresight basis and saying that if I issue out a ruling today with reasons, those particular reasons are then going to be challenged, and then the next thing we're going to sit up until the SCA and the court have fully decided and had this matter. Let's simply move along in an ordinary manner. There is a remedy, though, which is available for the former president if that's the case. Well, firstly, you can state and say, I want those reasons because I want to hear what is it that they have to say. Or secondly, say, if you're not going to give me those reasons, I want to record you not giving me the reasons as an irregular step as per Section 317 of the Criminal Procedure Act. Please note that I might use this against you at a later stage to say that I then received an unfair trial, hence those particular charges should be thrown out and I should be found not guilty.
Mpumelelo, let's shift focus a little bit and look at the ethical considerations for a prosecutor like Downer when facing repeated attempts to have them removed from a high-profile case. Is he under any obligation at some point to say, okay, you know what, let me recuse myself, or is it a case of his values, his beliefs, and what it is that he's been fighting for that keep him on the case?
Legally speaking, the case law would tell us that no, he's not under any obligation unless you engage in an act that can be viewed as if you are engaging in an illegal act. So if you're going to continue to do your work normally, continue engaging in conduct which is in line with the Criminal Procedure Act, in line with the NPS Code of Conduct and all the other things that are there, then simply you can still continue prosecuting this case. The leading case in this matter, which is S versus Porritt, makes it clear that prosecutors are not the friends of the accused. So it's by its nature in which they're going to be biased towards the state. They're going to follow a hard line when dealing with the accused individuals and are not going to find any favor. What can't be done, though, is that If a person is going to break the law, a person is going to engage in activities which are highly irregular, then the law is going to frown upon that. But the most important thing is that how do you deal with those activities and how do you make sure that they are recorded adequately and they are able to influence the outcome of the case? Is through the system in which I've stated earlier, which is Section 317 of our Constitution, of the Criminal Procedure Act, that states the irregular activities that are taking place. What we then do, further engage in external activities which are going to state or place on record with dissatisfaction. So if the conduct of the NPA is not done correctly, or a conduct of a prosecutor, complain to the Director of Public Prosecutions. There is a way in which we're able to do that and highlight all those facts. You also have the legal practice councils, because the prosecutors again are lawyers at the end of the day, and the Legal Practice Council Act applies to them. So it's one of those things in which the law is very particular to say, go and complain in whatever manner that you want to complain in, but this is not going to not a good enough reason to stop the process from going through. We can continue with the process, and if you found that there's anything flawed, in fact, it's going to be in your favor, because we can call it what is usually referred to as a mistrial, and you are going to receive a verdict of not guilty due to the irregularity having taken place.
Now, given the complex history and legal maneuvers in this case, what challenges might arise in ensuring that Jacob Zuma receives a fair trial, while also addressing the need for timely justice? In a separate conversation that you and I had around the Senzo Mayiwa trial, the duration of the trial, where witnesses and third parties are involved, is that people start to forget. They have no recollection of events that happened 10 years ago or over a longer period.
Definitely. And that affects both parties. You see, the quality and the quantity of the evidence is crucial. You need it as the prosecution so that you can be able to prove your case beyond reasonable doubt. You need it as the defense so that you can be able to prove the inconsistencies and poke holes in the allegations which have been laid against you by the state. So it's crucial that you find that witnesses start as early as possible, evidence is collected as early as possible. Now, in this case, people are going to forget, people are going to pass on, evidentiary material may no longer be found, making it difficult for both parties to do so. But our Constitution then dictates to us, also with the Criminal Procedure Act, as to how to handle these criminal matters. Constitutional-wise, it says the start must start and end within a reasonable amount of time, reasonable being. Any other objections that you would want to raise, make sure that you are able to raise them. And if you are not able to do so, then the court must step in using the Criminal Procedure Act, which is, I think, Section 346, capital A, that says, if there are any unreasonable delays which are taking place, make that application and make sure that within the application you are able to deal with all the reasonable or the unreasonable delay which is taking place. And the court may come to a response and say, you have taken this man to court for plus minus 10 years. There's no movement in the matter in which we have been dealing with. So we are going to strike this matter off the roll. And because they pleaded to say they're not guilty, you can't bring those charges ever again.
Well, obviously, I want to come back to an issue you raised, and that's an issue around incapacitation of either party or anybody who's critical to a successful prosecution or defense of the case in that matter. So what happens in that event where key witnesses or key individuals become incapacitated, can no longer contribute to either successful outcomes?
Well, it depends as to the nature of the incapacity that you are talking about. If a person has died, however, they've left a statement or an affidavit, their statement can be read into the record. The chances of that evidence being placed in enormous weight, though, is very limited, because you're then going to come back and say, is it something which is common cause agreed to by both parties? If the answer is no and it is disputed, the chances of that affidavit being thrown out, not to be considered as part of the evidence at a later stage, is high. Reason being, you can't cross-examine an affidavit. It's just a piece of paper. You need a human being in which you'll be able to test all these instances of accuracies so that you come back and say, this witness is credible. The information that you receive from this witness must then be valued at a high regard than compared to all others. So that's the bad part about not being able to collect evidence at a later stage. But it doesn't mean that all is lost. You can still try and submit that evidence, but there are many other hoops that you have to jump in order to have that evidence brought back in, which is why it's crucial, especially in this case, that both parties sit down together and say, we want as the NPA to make sure that there's a conviction, and want members of the public to see that the law is applicable. As the defense, we want to make sure that we are tried in the most fair manner, and we also want to clear our names. the quicker those processes go through, the better. The only way in which that can be achieved if individuals go to court, and once at court, they are able to prove whatever that their allegations are, and they're able to disprove and mark as lies whatever the allegations that have been thrown at them.
Now, Jacob Zuma has lost his appeal to his plea to have Advocate Billy Dunner removed as prosecutor for that arms deal corruption trial. And we were in conversation with Mpumelelo Zikalala, legal expert, unpacking the myriad of issues that are before the court. Well,